found myself ruined, wiped out. Everything I did in that case was decent. I did the best I could, and I was honest. And yet this court, whether it's your in-house law firm, it's your firm that you control, you gave them a green light to wipe me out, to falsely accuse me, and they've done it. And they're going to get up here in a couple of minutes, and they're going to continue with outrageous false statements if the past is any predictor to the future.
Thank you, Mr. Sommers. You have 10 minutes in rebuttal. Ms. Scott, representing the Office of Lawyer Regulation, you have 30 minutes.
May it please the Court, my name is Julie Scott, and I represent the Office of Lawyer Regulation in the current disciplinary proceedings. We are here today to discuss the disciplinary proceedings against Joseph L. Sommers. It is not the forum to discuss the disciplinary proceedings against Humphrey. This is not the forum to discuss the integrity of the DA's office, the Dane County judges, or this court. This is not the forum, as stated by Justice Shirley Abramson, to discuss if Mr. Sommers feels that the OLR and its agents committed misconduct and ethics violations during the disciplinary proceeding. His avenue, or the correct forum, is to file a malfeasance claim under SCR 2225.
But counsel, doesn't some of that information provide the context? We are here to determine not only violations, but if violations occurred, the level of discipline. And isn't that information important to provide context for our determinations?
Mr. Sommers had a right to present affirmative defenses in the underlying disciplinary proceeding. If he felt that there was anything that affected the results of the disciplinary proceeding, whether or not he engaged in misconduct under counts 1 through 3 of the disciplinary case, he had a right to bring those issues up during the disciplinary proceeding.
Doesn't that deal with whether or not there was a violation? As I said, if there is a violation, we have another issue to address, and that is the level of discipline. And I don't understand, I might be wrong, that's why I'm asking you. I don't understand why some of that information isn't available for purposes of context for the second part of our inquiry if we get to it.
Do you say that it's not available as to the evidence isn't on the record, or it's not available per se to discuss?
I don't know. I heard your comments to be really narrowing what we should focus on. That's what I heard your introductory comments to be. This isn't to talk about whether or not what went on in the circuit court was right or wrong. This isn't to talk about what went on with the district attorney's office is right or wrong. This isn't to talk about, and so I heard you really narrowing it, and I'm just asking, is it your position that we can't consider any of that? Isn't that information helpful for context? Now, you can say no to that, because that's a question, and I would appreciate an answer.
Well, I believe that the referee in his report and recommendation properly concluded that he could not make an ultimate determination as to whether or not the OLR or its agents engaged in misconduct under SCR 2225. However, he did listen to the affirmative defenses of Mr. Sommers and did take those facts into consideration in making his determinations in this case. If you look at the referee's report, the referee did indicate that his decision was based upon both the evidence and the witness testimony at the disciplinary proceeding, and also the motions and the deposition testimony that was submitted by Mr. Sommers throughout the case. So that was something that he listened to and he took into consideration in making his determination, but he couldn't make the ultimate determination in the disciplinary proceedings as to whether or not there was actual misconduct or malfeasance by any of the agents.
Counsel, count 1 is not what we're here about, because the referee did not make a finding that Mr. Sommers violated count 1 of the complaint. But I have some concerns about it, given Mr. Sommers' representation, that it was count one that really brought this whole matter about. And that all deals with the subpoena. And it was his frustration over the subpoena for Mr. McCoy that seems to have caused a lot of problems. Problems with the DA about his statements in regard to that, problems with Judge Bukowski about the way in which Mr. Sommers tried to proceed on that issue to get it straightened out, and then, of course, problems for him with the OLR because of the filing of the complaint. OLR has not appealed the referee's findings, so in my view, then, you are not asking us to conclude that OLR met its burden of proof in regard to count one, correct?
No, OLR is respecting the decision of the referee who found that Mr. Sommers did not violate count one of the disciplinary complaint.
Okay, my next question for you is, if you never had count one to file at all, and you had to file a complaint based on count two for the conduct that occurred in relation to that in count three, would the complaint have been filed anyway, or would there have been some other avenue that OLR might have proceeded upon?
No, if OLR would not have pursued count one of the complaint, although just to emphasize, the OLR still believes that it had sufficient evidence to pursue count one. However, the referee found that we hadn't met our burden. We would have still pursued the complaint based upon counts 2 and 3.
Okay. Now, it isn't always necessary, no, wrong word. It isn't always the habit of OLR to file a complaint when a lawyer does something that really is not appropriate under our rules, correct?
Could you clarify that question?
Sure. There are times when OLR will issue a warning letter to a lawyer rather than filing a formal complaint, or take some action that's less formal than a complaint. Is that fair?
There are different levels of discipline. We have diversion, we have public reprimands, we have private reprimands.
I'm just going to before the complaint. Say that I'm trying to see if there was some other way OLR could have approached this rather than filing a formal complaint if we eliminate count one. That's what is my purpose here.
In this instance, the OLR still feels that a suspension is the appropriate discipline in this case, just based upon a violation of counts 2 and 3. And if there is a suspension requested or recommended by the OLR, then a complaint does need to be filed.
Okay, so this is not a case in your view where the OLR would normally take a different tact other than filing a complaint, even if we just X out count one?
No, not when a suspension is an issue.
Well, how do you know what's at, I mean, do you
Not when the OLR has reviewed the complaint, the factual and legal issues with regard to the complaint under Wisconsin case law, the precedent, and the ABA standards for imposing lawyer sanctions, and have determined that a suspension is in line with the misconduct that occurred in this case.
Okay, I understand. So in this, even if we forget count one, for counts 2 and 3, it would have been your normal procedure to file a complaint anyway because you thought those counts warranted some type of suspension. Is that right?
That's correct.
Okay, great. Thank you very much. That helps me.
Ms. Scott, I've got a couple of questions. One, in looking at the facts here, I note that the complaint was filed in mid-November of 2006, November 17, 2006. First of all, can you explain to me why it's taken 4 years to get to this hearing today? At least given my experience on this court, which now is into its 15th year, I find it unusual that it would take that long. Can you give me some explanation as to why it's just short of 4 years from the time of the complaint till we're here today?
Sure. This was a very contentious, highly litigated case. There were there was a lot of discovery performed in the case. If you look at the referee's decision, the referee indicates a part of the extensive discovery. The referee states on page 3, second, there was extensive discovery. Sommers took many depositions and there were many conferences. The depositions included nearly all of the judges involved in the Raceback case, the director of OLR, the chairman of the district committee investigating the Sommers and Humphrey matters, expert witnesses involved in the Raceback case, members of the district attorney's staff, members of the Dane County Sheriff's Department, and others. I know that at one point that we were in the case, there was over 80 hours in depositions taken in the case itself. So there was a lot of discovery. I believe that the trial was adjourned at a minimum once, possibly twice, and I can't recall the reasons. But that's what took us so long to get to the case. The trial did in fact occur last June of 2009. And so it's been over a year since the trial concluded as well.
The other question I have relates to the OLR's recommendation for a 60-day suspension. And would you explain to me what the reasoning is of OLR in making that recommendation to the court?
The OLR, in making its 60-day recommendation, looked at both the Wisconsin case law as well as the ABA model rules or the standards for imposing lawyer sanctions. The most similar case to the misconduct that occurred in this case was the disciplinary proceedings against Painman, which is 216 Wiz 2D 440 574 Northwest 2D 232. It's a 1998 case where Attorney Painman was suspended for accusing the judge of tampering with the record, failing to obey orders of various judges related to the child support, custody support, continually interrupting the judge and impugning the intent of a judge. The misconduct in that case was substantially similar to the misconduct that was engaged in by Mr. Sommers at the May 24th, 2004 hearing. Yes.
Please continue.
Go ahead.
I looked at the Pangman case, and of course, Pangman, I think we did a 90-day suspension of Pangman. And I also recall a little bit of the Pangman case, and that is that there were numerous violations of court order regarding custody and child support, in addition to comments about the court sanitizing the record and the other discourteous comments to the court. Violating court orders is a big thing for me. You know, it's something you dasn't do. And you don't have that here. Now, how do you relate the two then, since what you do have is a commonality of being discourteous, speaking out in court, disrespect to the tribunal. So that's, there's a commonality there. You had that in other cases where you didn't ask for suspension. So my question is, shouldn't the violation of numerous court orders be a distinguishing factor in the Pangman case from this case?
Yes, and I agree with that, and that's one of the reasons why, if you look at the case, Attorney Painman did violate numerous court orders. He received a 90-day suspension. When OLR looked at the case and analyzed the case, the OLR felt that a 60-day suspension was more in line with the behavior of Mr. Sommers in this case. Unfortunately, there aren't a lot of other cases in Wisconsin that are substantially similar to the case of Mr. Sommers. However,
what about the Virginia Rose Ray case? In that case, I think you had, if I remember correctly, Judge Dyke was the subject of a difficult attorney, and accusations about Judge Dyke. And in addition, I think there was some other stuff going on. There were 11 other violations found in the case, including 2 trust account violations and 2 excessive fee case violations, and there the court imposed 60 days. So that's the same. Did you use the Virginia Rose Ray case as something to be considered?
The OR did not